Economic Development Committee will now come to order. I'll announce that items 1 and 2 will be continued to the next meeting of this committee, which we anticipate will be next week. So therefore, can the staff read items 3, 4, and 6 into the record?
Item number 3, Community Development Report, CRALA report relative to authorization to execute a termination OPA, terminating the existing OPA agreement between CRALA and Thermal Grand Avenue LLC regarding a now infeasible mixed-use condominium development at 8th Street and Grand Avenue in the City Center redevelopment project area. You want me to read 4 and 5 too? Okay. CRA 4 and 6. Okay. CRALA, CAO, and CLA report relative to a policy to ensure that projects funded from redevelopment revenues continue to be funded and that earmarked dollars are not reprogrammed without prior council approval. Item number 6, CRALA report relative to the criteria for establishing a redevelopment project area in Council District 11, including information as to why the Oakwood and Delray communities would not qualify for a RPA.
Okay. Thank you. Is anybody here for public comment on 3, 4, and 6? Public comment is now open on 3, 4, and 6. I do not see any public comment cards before me. Nobody is coming forward to speak on 3, 4, and 6 from the public. Therefore, public comment on 3, 4, and 6 are closed. With that, we'll move to receive and file these 3 items, 3, 4, and 6. Now, if you could please go to item 7.
Item number 7, CAO and CLA to report pursuant to motion Smith, Harness, Zine relative to establishing an economic development department. And this item was heard in Jobs and Business Growth and Tax Reform Committee on April 21st, 2009.
Okay. Thank you very much. Is there anybody here for public comment on item number 7? We're on item number 7. Is there anybody here for public comment? Okay, no one here from the public on item number 7 to speak, and there are no public comment cards before me, so public comment on item number 7 is now closed. I'd like to recommend that we hold this item in committee and request that the CLA and the CAO report back on options for economic development for the city, and request that the report consolidate all of the motions that the council has put forward, plus any other recommendations that our staff or other city departments have or anybody has or used to spur economic development in their community. And okay, seeing no other questions on that item, so therefore we'll hold that item in committee, and then we'll get a report back in the next 30 days. If there are any other departments that would like to include part of that report, please make sure you work with the CLA and the CAO, as we will hear their report in 30 days on that item. Okay? So with that, we now move back to item number 5. Please read into the record.
Item number 5, CLA and CAO and City Attorney to report and provide an analysis on what obligations the city has to the employees of the CRALA under the CRALA's existing collective bargaining agreements relative to the transfer of housing assets and functions from the CRALA to the LEHD.
Thank you. Is there anybody here for public comment on item number 5? Okay. We'll bring Steve up, and then staff can give their report. Steve?
Good morning. Appreciate the time to speak with you today. Unfortunately, I haven't had the chance to review the details of the CAO's report. It wasn't posted as of last night, but it's my understanding that that report identifies several issues with respect to bringing employees over. And without what I want to say, badgering the issue, we believe that the city has an obligation to bring those employees over. It's already decided that it would transfer the functions of the housing from the CRALA to the city, and as such, it has an obligation to those employees. But with respect to the benefits of bringing those employees over. I believe even the CAO has acknowledged that the staff of the LAHD does not have the experience or the skills that the CRA-LA employees have, and that deserves some credit and some merit in terms of what is being considered here. You know, the classifications that exist over at the CRA-LA already have job specifications outlined, and I don't see that there is that much difficulty within the CAO's staff in order to review and incorporate those into the city's current system if that's what's necessary. But in any event, if there still exist those problems, then we respectfully ask that you give us an opportunity to resolve those. Transfer the employees over, you know, protect them, protect their jobs, and direct the CAO to sit down with us and work out any of those differences. At a minimum, we think that is what the city needs to do, and it's the right thing to do, and we respectfully ask for that consideration. Thank you.
Thank you. Thank you very much, Steve. Okay.
Tom Coltis, CAO
Can you pull
staff.
the microphone a little closer?
Tom Coltis, CAO staff. I apologize for the report being late, but some of these issues are a little more complex as we got into them. The report before you speaks to what our obligations are relative to the CRA employees and the CRA labor contracts as it relates to the transfer of the housing function. The state legislation on the abolishment of the CRAs contained language that said that if you became the successor entity, then you were obligated to continue the labor contracts. And on January 11th, the City Council voted not to be the successor entity. By voting not to be the successor entity, that ended the city's obligation relative to those contracts. And so at this point in time, no other taxing jurisdiction has stepped up to become the successor entity, and when the governor appoints the designated local authority, three-person panel, then that will become the way in which the CRA functions will be closed out on a go-forward basis for those functions. The labor contract that we have, that the CRA has with its employees, contains a provision, and it's basically an existing benefits, a retention of existing benefits provision. And that is a provision which you commonly see in labor contracts. The purpose of that provision is to cover those areas that may or may not have been discussed during the course of the renewal of the contract. And if they weren't discussed, it is not, you do not want to just end it by virtue of saying you didn't uncover it in the labor contract. It's a continuing benefit. It's a continuing condition of employment. So we have a provision that says those things continue even if they weren't discussed. Included in the CRA's retention of existing benefit provision was lines that spoke to if a function of the CRA is transferred to the city, then the CRA will continue the benefits for that function, even though the function has been moved to another entity. And that provision would be perfectly fine, except in this case, the CRA ceases to exist. And so the CRA is not in the position to continue the benefit, and the City of Los Angeles is not obligated by virtue of that language to continue the benefit. So it is recognized that these are ongoing projects, and they require ongoing monitoring, and some staff will be required to do that. But in terms of the obligation under the contract to use the CRA employees to continue that work, that does not exist under the contract. In terms of bringing employees to the City of Los Angeles, the Personnel Department can speak to this far better than I can, but it is not a situation where you can simply pick up a group of employees with their existing benefits and their existing structure and bring them here and then call them city employees, because We don't have those systems and we don't have those benefits. And they are not in our retirement system. Their salary structures are different. Their benefit structures are slightly different. If the objective is to bring people here to continue the work of those work programs that are necessary to continue the housing element, then it would be appropriate to bring them here as some type of city employee. And how we would get them here is not that straightforward either. And the City of Los Angeles is a civil service environment with testing requirements. And so normally, if you want a job with the City of Los Angeles, you show up, you take a test, you get put on a list, and you get appointed. And we are a promotion from within organization as a general policy. And a lot of these jobs are what are at the top end of the salary scale. Top, not the top, but the high top. And we would normally promote people to those positions. So you're talking about bringing in a group of people through some mechanism. Now, there are mechanisms to bring people in, but if you bring them in, you bring them in with our structure, not with the existing structure that they have under the CRA. And at this point in time, you do not have any labor contract that says that you have to bring them over. And that is consistent with our discussions with the city attorney on there is no requirement to bring the number of people over. You can transfer the function, but you don't have to bring the people.
So going back to part of your original explanation, your explanation at the beginning, there's a distinction between the CRA continuing as an organization and then potentially being folded into the city versus elements of what they did and some of those functions continuing to happen somewhere within the city. There's a distinction between the two when it comes to obligations to the employees of the current, or as of last night, former CRA.
Right. The state law was not a model of clarity. I think everyone would agree upon that. But it was clear that if you chose to become the successor entity, then by making that policy choice, you would be required to continue the labor contracts and the benefits as they existed. When the city chose not to do that, that ended that obligation. Now, there are functions, and the housing is one of those functions, which the city can move over to do that work, to choose to do that work, and to continue the work and the monitoring work that is actually required of those development deals. That is not becoming the successor entity. That is moving a function and taking over and assuming an additional work for the City of Los Angeles.
And also, you're pointing out that there's a distinction between an obligation to take someone with certain title in the former CRA and then the obligation to bring that person with that skill set to handle certain responsibilities wherever they may take place in the future within the city. There's no obligation to take that individual and move them over, either bump somebody else or create a new position. That filling of that talent is up to the city to decide if they want to have somebody internally take it on, promote somebody up into that position, or hire someone to take on that distinct skill.
That's correct. When the council made the policy, when it made the decision to take the housing function into the housing department, it really places on the management of the housing department the obligation to figure out the best way to do this work and the resources that they need to do that. Now, my understanding is they're going to come back with an implementation plan, and that implementation plan should cover those aspects. If they need specific people in the CRA that are doing work, then they need to identify that in their implementation plan and then work with the personnel department to determine if there is a way under the confines of our system to bring that person over.
So basically, if the housing department realized that they needed somebody with a certain skill set, and that person with that skill set happened to be in the former CRA, then that person would basically potentially be brought on the way some third-party individual would be brought on from outside the city.
That's correct.
Okay. Any question?
Yeah. Is the city attorney present
We have another city attorney present, yes.
on this item? Yeah. In the CAO's report, it says it was determined. Was there a legal opinion to that effect? Was there a clarification in the court?
Oh, clarification with regard to what, sir?
Okay, in the CAO report, it says, while AB 126 was not a model of clarity, it was ultimately determined that if the city chose to be the successor agency, it would have been required to assume the labor contracts.
That's pretty clear. from the
Ultimately determined by who? Was there a clarification in the court?
statute. In court, not that I'm aware of, no.
Okay, so we don't know that the court would respect that opinion. Where does that opinion come from?
It's part of the statute, sir.
No, I'm asking, who made the determination that AB 1X26 did not require us to carry over the labor contract should we choose to take on part of the responsibility of the CRA?
Oh, excuse me. Well, in part I did, sir, but
And so tell me, what section were you looking at that gave you that interpretation?
there are two sections to the statute. There's the section, and forgive me, I don't have the statute right in front of me, so I can't give you the exact number, but
But we had asked for a report back, and we have nothing in writing from the city attorney, so I don't have a legal opinion in front of me. All I have is a CAO statement about what he thinks the city attorney said to him.
Well, that would get into the areas of attorney-client privilege, and so we would need to go into closed session on that.
The
pursuant to
fact that
pending
we don't have a
litigation.
written report from the city attorney when that was what was requested, that does not have to go into closed session. Do we have a written report as requested?
I have a written report, sir, but it's not appropriate for public session.
That's why that would have to be
Public
discussed.
session, I can't even have it? I don't have it before me.
Excuse me, council member, as chairman of this committee, I'd like to clarify. We asked for a report, and to be involved was the city attorney, the CAO, the CLA, the housing
Right.
department, CRA, et cetera. However, what we have before us is a written report from the CAO.
The city attorney has just said she has a written report. I would like to see it.
Well,
That would need to be discussed in closed session
We need
because
to
the
discuss
report would not be a public
Okay.
document.
That's fine with me. I just want to see the
Well,
report.
let's go into closed session.
Then, let me make the announcement, then pursuant to Government Code Section 54956.9B13C, the committee will convene in closed session.
And,
to
and
meet
Mr.
with
Chair,
legal
I would also
counsel
say this is a
regarding potential
personnel matter. I don't know why this matter should not be referred to the Personnel Committee.
We'll determine that.
Yeah, well, I think Mr. President will determine that, but this is a personnel matter clearly, and I really believe it should be in the Personnel Committee.
Okay. And as many issues, we discuss them in more than one committee as they have jurisdiction in various committees. Okay, so if we could just have the necessary city staff present as we go into closed session.
Do we get to keep a staff or?
Yeah. Me. All right. Okay, we're now back in the open session, after discussing some legal matters in closed session. I just want
Let me
to
just make the announcement that the committee met pursuant to Government Code Section 54956.9B13C, a written letter from AFSCME that made a threat of litigation was the basis for the closed session, and no action was taken.
Thank you. I just want to, now that we have remind the full complement of the committee, we have a quorum, that we had put over items earlier in this committee. We put items 1 and 2 over until the next meeting of this committee, which is anticipated for next week. And then also items 3, 4, and 6, we just received and filed those items. And then item number 5 was a report for information purposes only. So we note and filed that item. And then we just heard item number 7, and so we did not take any action on that item. And as was mentioned right before going into closed session, it certainly pertains to matters of the Personnel Committee, so I presume that it'll be discussed in the Personnel Committee. The President will assign it to the Personnel Committee, and the Personnel Chair can take that up as they wish. So with that, there are no more items before this committee. Is there anybody here for general public comment? Okay, nobody here for general public comment. General public comment is now closed. This committee is now adjourned.
Thank you, Mr. Chair.